In a year of some important birthdays for the U.S., here's another one. 50 years ago this month, on January 30th, 1976, to be precise, Supreme Court issued a seminal decision, Buckley v. Valeo. It ranks as one of the most important free speech decisions in the history of the country, arguably much more than the one that gets all the attention when we talk in particular about campaign finance issues, Citizens United. Buckley paved the way, even as it struck a critical blow for political free speech, which makes it particularly worthy of some meditation and honor. And that is my welcome to this very special panel discussion, which is presented by the Institute for Free Speech to help commemorate the 50th Buckley anniversary. This discussion is, in fact, part of a broader anniversary project that includes an essay series the Institute is publishing in partnership with the Volokh Conspiracy, which provides a perfect opening to introduce the participants. I'm Kim Strassel, a member of the editorial board of the Wall Street Journal. And joining me here, the real experts, we have Brad Smith, the founder and chairman of the Institute for Free Speech, the former chairman of the Federal Election Commission. He's one of the nation's foremost experts on campaign finance law and political speech. Joel Gora is a professor of law at Brooklyn Law School and a former attorney for the American Civil Liberties Union. While at the ACLU, Joel argued Buckley v. Valeo before the Supreme Court. Eugene Volokh is a legal scholar who is the Thomas M. Siebel Senior Fellow at the Hoover Institution at Stanford University and the co-founder of the very popular legal blog, which I read all the time, the Volokh Conspiracy. So let's just start here, and welcome to all of you. Thank you so much for being here. Let's lay some groundwork and explain why we're doing this, why this decision and this anniversary are so relevant. Brad, you recently wrote a piece for the Wall Street Journal with a pretty striking headline. It certainly made me stop and want to read it. It said, "The 1976 Supreme Court decision that saved democracy." That's a pretty big claim. Explain that to everyone.
Yeah. So as you pointed out, nowadays everybody focuses on Citizens United, but I think people who are in the know, who study this area, whether they're practitioners or lawyers or scholars, know that really Citizens United, to a very substantial extent, is simply following the principles of Buckley v. Valeo. And for 30 years before Citizens United, it was Buckley v. Valeo that was the whipping boy of campaign finance reform movement. And even now, knowledgeable people in that movement are pretty frank about saying, overruling Citizens United won't accomplish what we really want. We really have to overrule Buckley. So what is it that Buckley did that leaves me to make such a bold claim? Buckley did address the 1974 amendments to the Federal Election Campaign Act, and it had a couple of key points. It's a massive decision. It's well over 200 pages in the U.S. Reporters. It's one of the longest ever. It's an important administrative law case, which people often overlook. But just focusing on the core campaign finance holdings, if we were to just cut it down to its bare essentials, it said Congress can limit contributions directly to candidates and parties and political committees that are made for the purpose of electing people to office in order to prevent corruption or its appearance. But at the same time, the Supreme Court struck down limitations on expenditures, what people could spend, either what candidates could spend or what groups and individuals could spend separately, independently from the candidates. And to me, it's this latter holding that is really the heart and soul of Buckley and what leads me to make that strong statement in the journal. If you think about what the law did, the law limited candidates to spending no more than, it had different limits for U.S. Senate and for president and so on, but to give it an idea, for a U.S. House seat, it was $70,000. Now, at the time, that was not nearly enough to campaign for an open seat or for a challenger to unseat an incumbent. Even if we had adjusted it for inflation today, it would be about $400,000, still not nearly enough. But, because people think that's a lot of money. But remember, we're talking about communicating to congressional districts now that have almost 800,000 people in them.
Right.
And so you've got this very low expenditure threshold that congressmen or candidates for Congress would have had. Even more importantly was the provisions on independent spending. The law said that if you spent that you could not spend over $1,000 relative to a candidate. And this would apply to any group. So for example, the National Rifle Association, Planned Parenthood, the NAACP, the ACLU, just any of these groups, $1,000. And remember, none of these limits were adjusted for inflation. We could say maybe Congress would have adjusted them. So I emphasize they were totally inadequate even at the time. But what's even more important is they weren't adjusted for inflation in the law. Many of the portions of that law that survived Buckley 50 years later have never been adjusted for inflation. Congress and the reformers have no interest in doing that. So you would have had $1,000 limit on what these groups or individuals could spend. Now think about that. That doesn't buy you probably, I would guess, a 3-inch column, single column ad in the New York Times today and the Sunday Times. I know that it buys you basically about 1 30-second spot on Wheel of Fortune in a mid-sized market like Flint or like Richard Nixon's legendary Peoria, where everybody wants to go. And so essentially what they were doing was cutting out of political debate in the United States unions, trade associations, advocacy groups like the Sierra Club or the Chamber of Commerce. All of these groups would have been barred from talking about anything, quote, relative to a candidate. So it's not even just advocating their election or defeat, but what you could say about things. And all of, therefore, the political debate would have been funneled through the mainstream media, which was exempt, remember, from the law, as if the mainstream media would never have a partisan agenda or anything like that they might
Never.
want to be pursuing. No, never. It's just inconceivable. And the end result, therefore, as I say, would have been a political system that would really have been a non-political system, that the American people in the groups and organizations they belong to as individuals would have been told, you sit there on the sidelines, you let these candidates talk with the little bit of money we give them, and then you listen to what these handful of people in the press report, and that's your democracy. And then you do get to go vote, but you're totally restricted. If they don't talk about what you want to talk about, tough cookies. You can't force that issue to the agenda. If you think a viewpoint's not being represented, you're out of touch. If you think the media slant it one way or the other, doesn't matter. You can't really say anything. And so that's why I make that bold claim. To me, that would not be a democracy at all. And that's why I say that Buckley really, through its ruling on expenditures, that you could not prevent people from spending their own money to talk about the political candidates and issue they cared about, really saved American democracy.
Yeah, I mean, it's a terrifying thought, the world you described there of what it would look like. I mean, just to clarify too, would you say that this was the first decision the Supreme Court ever made that really recognized that money is a fundamental aspect of speech?
In any clear way. I mean, the court had it touched on it in certain other cases, both campaign finance and some others, without ever really specifically addressing it. And it's worth it. Just to elaborate for a second, and maybe Gene or Joel will want to add more, but just the point, a lot of people, their initial reaction, I think, is very normal, which is money is not speech. Money is money, speech is speech. But we know that if you limit money being spent to facilitate a constitutional right, you infringe on that constitutional right. So if we said, sure, you're entitled to a lawyer, but you're not allowed to pay one, that would be a problem. If we said, you can practice your religion, but you can't spend any money to build or maintain churches, to buy hymnals, to pay pastors, we would all recognize that infringed on the right to practice religion. And you could go through almost any of our rights under the Constitution and think about it in those terms. And I think the court recognized that the right to free speech, again, you talk just a basic congressional district, 800,000 people, if you're going to have that right have any meaning, you have to be able to communicate to a large group, and that does require some expenditure of money.
Joel, I want to ask you, it isn't always the case that in a panel like this, you get an actual man who was on the scene, but you were actually that man on the scene. You argued this in front of the Supreme Court. Can you lay out for us some background on how this case evolved, how we got to the point where we had this challenge, but then also the case itself, its path to the Supreme Court? Because my understanding that, a lot of lower court judges were pretty hostile to some of the challengers here. It wasn't necessarily clear we'd get this result.
Right. Well, thank you. First of all, I've been privileged to work on First Amendment issues since I was a summer law intern for the ACLU a long time ago. And so for me, it is such an honor to be on a panel with such First Amendment giants as Gene and Brad, and such a wonderful journalist exercising another part of the First Amendment panoply of rights as you. So I really am so proud to be here. I think let me spend a moment on an origin story. Because a lot of people ask me, the ACLU, it's a liberal group. Why were you challenging all these campaign finance reforms? Well, here's the answer. 4 years before Buckley, Congress passed the Federal Election Campaign Act, the original one of 1971. And its approach was trying to deal with the fact that the 1968 presidential election had a lot of television ads. And you may remember there was a journalist who wrote a book called The Selling of the President. And the theory was presidents were being sold on TV like cornflakes, and we had to do something about that, and we had to get more disclosure. So those were the two focuses of that law. Number one, disclosure of anybody that spent any money to influence the outcome of an election over a certain amount. And number two, and this is hard to believe they thought this made sense. They came up with what I call a Rube Goldberg device. They were trying to limit not all expenditures, but media expenditures. They were trying to get those ads off of television. So what they said was all candidates for federal office are subject to limits on how much they can spend on media advertising, number one. Number two, anybody outside, any individual or group that wants to spend money supporting or opposing that candidate has to get permission from the opponent of that candidate that it wouldn't violate that opponent's spending limit to have money going out favoring the opponent and disfavoring the candidate. So if you ran
That's
an ad
crazy.
as a group pardon me?
That's crazy.
It is crazy. So you ran an ad that a small group of left-wingers from the Upper West Side of Manhattan put together some money. I think it was about $40,000, and they ran a turgid, dense, technical, legal two-page ad in May of 1972 when Nixon was running for re-election, attacking him, saying that he was a war criminal for bombing Cambodia, urging the impeachment of Richard Nixon, and putting up an honor roll of those 5 members of Congress who had voted for impeachment. You would have thought they would have gotten a medal for that. I mean, here they are, citizens using their own funds to speak out in an ad in a newspaper criticizing the government. Wow. Instead of getting a medal, they got a visit from the government. And the federal government said, maybe you haven't heard about this new Federal Election Campaign Act. But number one, before you can run an ad like this again in the future, you have to file a report as a political committee. You have to disclose everyone who gives you more than $100 a year for funding, things of that kind. And by the way, you have to get the permission of George McGovern, Nixon's opponent, and some unnamed candidates running against the 5 members of Congress, that your expenditure that helps them does not cause them to go over their media limit. And by the way, if you don't do that, the New York Times cannot run your advertisement, cannot accept your advertisement. And if they do, they may go to jail. Well, these people, when the government showed up, they came to the ACLU and they said, what's going on here? We said, what's going on here? We can't imagine a law like this. We really weren't paying much attention. There were a lot of other issues in the early 70s. We weren't paying much attention to our dismay. So along came the law. This group is sued by the government. The United States versus the National Committee for Impeachment. This is all in the summer of 1972. And the district court just pro forma gave the government the injunction, told them they couldn't speak, they couldn't run ads, nothing. Well, we were involved and we took it to the Second Circuit. And I believe the Times filed a brief supporting us, but it did in one of the other cases. And what we said was, you can't have this. It both violates the First Amendment, it violates associational privacy. You can't have it. And the Second Circuit said, you're absolutely right. It makes no sense. And by the way, issue groups like you should be free under the First Amendment to criticize politicians without being ensnarled in all of the campaign finance laws that they had just enacted. And then we filed the ACLU's own suit because we wanted to run an ad condemning Nixon and praising his congressional opponents. And we took it to the Times and they said, sorry, we can't run it unless you go out and get all this approval. We know the Second Circuit said it's okay, but that's only one court and we can't take a chance. So we filed suit, ACLU v. Jennings, fall of 1972. And we got a 3-judge court in Washington, D.C. to say, you're absolutely right. that this Rube Goldberg mechanism is a classic prior restraint. The government says you can't speak unless you get a bunch of people's permission. And number two, the disclosure requirements should not be applied against nonpartisan groups, issue groups like the ACLU. We said, great. Oh, we won. We don't have to worry about it. Well, later in the decade came Watergate. Watergate actually was happening while the litigation was happening, but unrelated. Watergate comes along, it increases, and Nixon finally is driven from office in '74, and that gave lit the fuse under the people that have been trying to get campaign finance reform for decades to come up with a law that was just sweeping. We called it the mothership, because the original law was just about media advertising. It said you needed permission. This law basically said you couldn't do it if it would cost more than $1,000. This was really worse. All expenditures on politics were limited. Candidates, parties, independents, ACLU, etc., and plus more rigid disclosure, plus an extra disclosure provision to get issue groups like the ACLU that ran box scores, plus public funding for the first time, but targeted only available primarily to the two major parties. And finally, to enforce all of this new systemic regulation of free speech and of democracy, a Federal Election Commission, the majority of whose members were picked by the House and Senate. I mean, I have to say, one of my fantasies is somebody one day is going to say, "Hey, the incumbents who run for office are writing the rules for how they get to run for office and how their challenges what they have to do." That's just the worst conflict of interest. It would be like having the home team write all the rules and pick all the umps.
Exactly.
And so we joined, ACLU and others joined a strange bedfellows coalition. And it involved Senator Eugene McCarthy on the left and Senator James Buckley of New York on the right. And they were kind of the poster people for how they use access to contributions that were now illegal to spend money that was now illegal. On the one hand, to knock off a sitting president in '68 because of the war in Vietnam. In the case of Buckley, to be, I think, the first third-party candidate to be elected Senate from New York. And they said we could not have done this anymore because of the draconian restrictions of this statute. So you had terrible spending limits, and they also applied to the ACLU. Because as Brad pointed out, any person, and person included a group, who spent more than $1,000 in an entire year with respect relative to a candidate could not spend any more. So it was a one-shot deal. You had your ad and that was it. Number two, the disclosure in the new law was worse. Plus, they put in an extra section to target the ACLU. Plus, as we said before, the fox guarding the chicken coop. So we put this coalition together and we wanted it to say, look, this is bipartisan. This is nonpartisan. This is people across the political spectrum who disagree on everything else except for the fact that this law is terrible. And we said it was a throwback to the Alien and Sedition laws of 1790, whatever they were. And so we filed suit. It was all really quite exciting. I mean, you have to imagine, I'd worked on a lot of First Amendment cases, Pentagon Papers case, stuff like that in the mid-'70s, but this is heady stuff. And a group was put together. Our lead counsel was Professor Ralph Winter, went on to become a great federal judge. Bryce Claggett, who's a huge partner at Covington Burling, and I don't know whether this has come to your attention, a fellow named John Bolton, you might have heard of him more recently. He was one of the counsel, and it was kind of like David and Goliath. We sort of felt, we're the true outsiders, and the establishment has come together and basically tried to shut down political speech with respect to democracy, and we're the only voices who can try. So we filed this suit, and we had 6 months. Oh, Buckley put a provision in this is all not in the weeds, but the 74 post-Watergate, Nixon's gone, let's do it, statute was called the FECA Amendments of 1974. But as I said, that was the mothership. Those are all of the huge provisions that were so expansive and so restrictive. And so Buckley got a provision put in that any challenges to that law would have to be heard by an en-banc federal court immediately. So we filed suit. We had 6 months of discovery and all that stuff. And we had an argument in the en-banc DC circuit in Washington. Again, very impressive stuff. All the judges and all the attendants and politicians, everything really exciting. And we got into the argument, and we kind of felt at the end of the day, it was like a 3-hour argument, that we were kind of not being heard, that we really weren't getting a hearing, that because most of the judges were kind of asking us very hard questions, more hard than they had to. Only a few judges seemed to be concerned with the total restriction of free speech. And And so, case argued in June. In July, or whatever, later this summer, I was on vacation in LA where I grew up with my family, my wife, and I get my mom says, there's a fellow on the phone named John Bolton. He wants to talk to you. And I said, great. So I said, John, he said, the decision came down from the circuit. I said, great. What'd they say? He said, you won and we lost. I said, what does that mean? He said, the only thing they struck down was the disclosure provision against the ACLU and all the issue groups. Everything else, they swept the board and they won all of the other thing. The court upheld everything and basically deferred. So at that point, we had to go to the Supreme Court, and we did. And we filed our papers in the Supreme Court. The court certainly treated it as the kind of special case you talked about. It set aside the whole day for argument. I don't know how often the court has done that, but it's a rare thing to do. And the courtroom was packed with Senator Ted Kennedy and all the famous politicians. It's really heady stuff. And so we started the argument. Professor Winter argued against the limits. I argued against the excessive disclosure. Bryce Claggett argued against both the commission and the public funding, and there were prominent people on the other side. A former Solicitor General Archibald Cox represented the government on spending. A top government lawyer, Daniel Friedman, represented the government on disclosure, and Lloyd Cutler. Wilbur Cutler Pickering represented the law on campaign finance, and a professor named Ralph Spitzer, I believe, represented the government on the commission. And the argument went for the whole afternoon. But when we took the 2 hour break for lunch and we were down the cafeteria, we were almost giddy because we said, for the first time in this case, we feel like we're getting a fair hearing. We feel that the judges are just as interested in how the government can justify this as they are interested in how we should be striking it down. So we came away from the day cautiously optimistic. And I don't want to monopolize our wonderful conversation here. So I'm going to let somebody else want to talk about the decision. I've got some views on it myself, but I feel like I'm engaging in a filibuster. So.
No, can I just say, like, I think a lot of people, they hear the words campaign finance and they think dry. That was the most colorful and animating description of a Supreme Court case.
Thank you.
I wish I'd been there.
I might say one other thing to monopolize the. One of the kind of subtext for us ACLU types was, again, how can the ACLU be challenging this reform law? And so we had to spend a lot of time convincing the people who were sort of on our side. I'm not sure we did a very good job of it, but we were making the point that all the different people of whatever political persuasion were harmed and limited by this. And it was David and Goliath was the government, and it was laying out all the rules for the battle, and that's just wrong.
Well, I think that's a really important point to make, the nonpartisan cross the aisle nature of this, because that was a coalition that held up for many decades too. We've seen some splintering of it, I think, unfortunately, in more recent years, but it was very important to the cause of free speech, the players that all got together and were involved there. Eugene, let's talk a little bit about those holdings, the decision itself. Walk us through what some of the in your mind, the most important and major holdings were of that. But then also, this was not a perfect decision by any stretch. There has certainly been some real legal critiques of Buckley too. So talk about a few of those that have come about.
Sure. So it's a very long decision, and there are parts of it that have to do, for example, with the structure of the Federal Election Commission and limits on legislative role in appointments of members of the commission. I'm going to set that aside. Let's just focus on the key points. As a general matter, Buckley said that independent expenditures are broadly protected by the First Amendment. Again, not because money is speech, but as Brad pointed out, restricting the spending of money for speech is a restriction on speech, just like restricting the spending of money on a private education would interfere with parents' rights to privately educate their kids, not because money is an education, but because money is necessary to get educated. So as a general matter, restrictions on independent expenditures, spending by people who are not coordinating this with the candidate, those are constitutionally protected, and no caps can be put on them. Likewise, restrictions on candidate spending of their own money is constitutionally protected. Excuse me, spending of their own money is constitutionally protected. Restrictions on it are unconstitutional. Likewise, caps on total spending by a campaign are unconstitutional because those caps would necessarily diminish the amount of speech that the campaign can engage in. At the same time, it generally upheld contribution limits, suggested that contribution limits, if they're too low, might be unconstitutional, but a contribution limit of, at the time, $1,000, generally permissible. In part because contributions were seen, and this is actually one of the things that people quarrel with the decision about, but contributions were seen as less likely to tend to corrupt candidates. Excuse me, contributions are seen as more likely to corrupt candidates, and independent expenditures as less likely to corrupt candidates. So because of this potential corruptive effect, contributions could be quite considerably limited. The court also generally upheld various kinds of disclosure limits, but that's all, again, a more complicated matter, which I'm happy to leave more broadly. Happy to leave to others talking about this more broadly in the rest of the conversation. As a theoretical matter, the court recognized or decided several broad points. One is that there is a very important government interest in preventing corruption, and that can justify interference with what would otherwise be potentially protected activity of contributing to a candidate you support. But there is no adequate government interest here in just trying to equalize people's resources and equalize the amount of speech that is spent on, say, both sides of a campaign. That's the big picture. Now, I actually, as it happens, very rare person who actually agrees with Buckley on both the expenditure and contribution side. Generally, lots of people think that Buckley got it wrong as to independent expenditures, and it should have upheld not necessarily $1,000 cap, but more broadly recognized the power to cap independent expenditures. Considerable number of people think that it got it wrong on both expenditures and contributions, that it got it wrong on contributions because both in expenditures and contributions should be fully protected. I actually think this line is a sensible line. But because the other panelists are pretty broad supporters, at least of a right to engage in independent expenditures, I wanted to make sure I highlighted the other side's argument. So what I want to flag is a couple of important objections that people have made. One is that, in fact, the argument is that limiting the speech of some in order to maintain kind of equality in debate is actually a sensible thing. And something that the government ought to be able to do within limits, to be sure. Again, that's actually not my view. But I do think it's an important point that needs to be aired. And one way of reflecting that is in many important decision-making processes, in many important contexts, that's exactly what we do, right? In court, we try to be pretty scrupulous about making sure that both sides have time to speak, and both sides have the similar opportunities for the jury to listen to them. Now, we don't cap the amount of money people spend for lawyers, so that could be an argument in favor of First Amendment protection for expenditures. But we do at least make sure that there is time, and we don't allow one person, because they have a very good lawyer, to be able to speak for many hours, whereas the other person, we're charging them by the minute to speak in court, and they only get to speak for 15 minutes. We think that's not a good judicial process. Likewise, if we put on a debate, just as either private organizers, let's say a university puts on a debate on some subject, we probably expect them to invite people from both sides and give them equal time. So the argument would be that this is something that is important in order for the public to be able to make sensible decisions, just as it's important for a jury to hear amply and more or less equally from both sides, just as it is important for people listening to a debate who want to be informed to hear equally from both sides. Likewise, it's important for the public to be able to do that in this other very important decision-making context. So that's one version of the account. There's another version which says, look, we're not going to get perfect equality in this respect, and maybe too much would be lost by trying to get perfect equality. It isn't fair to say to people you can't buy an ad in a one-page ad in the newspaper. That's too much of a burden on your speech. And maybe also it means if you can't spend enough money, then people just won't hear enough about this. But maybe there should be limits. Not $1,000. How about $1 million? Maybe it isn't right in a democracy to have people who have millions, billions of dollars be able to spend all of this money in order to affect a public debate when the other side may not be as well funded. So maybe we can't have perfect equality. Maybe we shouldn't even try to have perfect equality, but maybe we should be able to limit it, albeit with higher limits. Although, of course, an interesting question is how a court is going to decide what's too much and what's too little. Incidentally, something the court has had to do with regard to the caps on contributions. A second concern has to do with bribery, but also with its flip side, which is essentially a form of extortion. So the worry is that indeed contributions and even independent expenditures are means for people to buy politicians is kind of a conclusory term, but let's say to buy access to politicians. That maybe it's the rare politician who will say, yes, I'll vote your way because you spent all of this money. But it's also the rare politician who will say, I'm going to ignore the fact that you spent all this money to support me and the prospect that you might spend all this money to support me in the next election. I'm just going to completely ignore it when I'm making my decisions. At the very least, presumably the politician will take a phone call from a big donor, a big independent spender, where they wouldn't take a phone call from a random citizen. That's just human nature. I think there's little doubt that there's some degree of this kind of extra influence. And the question is it fair in a democracy? We all agree that outright bribery, here's money if you vote my way, is something that should be criminalized. I think almost all, hard to say all, probably all on the call would agree about that. But is it really that different when somebody, again, by spending and having the prospect of the next election cycle, spending a lot of money, gets access, as I think there is evidence that they do get extra access, to politicians or even at least to the politicians' staffers and others? But the flip side against the extortion point is, imagine you're a businessman, someone calls you up and says, would you donate money to this campaign? They don't have to say, and if you don't donate money, then the candidate will vote for some law that is bad for you. But there's always that worry, right? I mean, if you're someone who's at all worldly and understands the way human nature operates, you know that if you say no, then if the candidate is elected, at least they'll be a little bit ill-disposed to you, maybe not certain, maybe not for everyone, but there is this worry. Isn't it just safer to, when you get this call, to say, sure, I'll write you the check? And that's true particularly for contributions, but the same could be true with regard to independent expenditures. That if somebody says, we are independent of this candidate, but we're strong supporters of this candidate, and we'd like to think you are too, can you donate $10,000 to this? And the candidate is every prospect, looks like they'll be elected. In any case, again, the businessman may say, if I say no, am I certain that it won't get back to the candidate? No, I'm actually pretty confident that it will get back to the candidate. I remember talking to somebody who was a federal employee and barred from contributing to political campaigns, that particular class of federal employee. And I asked, it's a joke or anything, aren't you upset about this limit on your First Amendment rights? And he says, I'm delighted by this limit on my First Amendment rights. Because this way, when all my buddies are running for office and call and ask me for money, I could say, oh, I wish I could support you. But I can't. I'm not allowed to, right? And this was something where this person, again, was kind of joking, but not totally joking, was talking just about social pressure. Like it's hard to say no to a friend who asks you for money for his political campaign. But I think the concern is even more serious when you have economic interests that'll be in front of that person. So those, I think, are very serious concerns. Again, on balance, I think that the decision in Buckley is perhaps the best way of dealing with these concerns and the free speech concerns that we can find. But it is quite imperfect in many ways. Again, maybe because life is imperfect. And I just want to make sure that we aired these, I think, very serious concerns.
Well, I think that's a very, very helpful because it helps explain some of the thought process that may have gone into those who came up with some of these restrictions in the first place, as faulty in my mind as they were. But what animates people. Brad, just to sort of round this up before we go back and talk about a few more specifics of the Buckley decision, but how has the case, the decision overall, helped to shape jurisprudence since then? And how did it lead to cases like Citizens United?
Well, that's a great question that I think we should address. But I do want to, I think we should take a moment actually to sort of address the objections that I think Gene has put forth very, straightforwardly. And I think those are right. And by the way, I think, and I think I can speak probably for Joel here and for Eugene, is that, most of us on the pro deregulatory side, if you will, would not belittle these kinds of concerns about money in politics. I mean, Americans hate money in politics. It strikes them intuitively as kind of contrary to the idea that we're all equal. The possibilities for corruption are there. So these are real. We could go into great detail about what are the objections to the objections, and point out that money doesn't always work the way that people think it's on. But my simple basic argument would be to say, look, the First Amendment is there largely precisely to keep government from making these kinds of decisions as to who's spoken too much, who's not spoken enough, how much is just enough in the public arena of politics. And it's there to prevent that precisely because we don't really trust government to do that fairly. For one thing, they have a vested interest. As you pointed out earlier, the members of Congress have a usually vested interest in how the FEC acts, what the rules are. We've seen when limits are set on spending in races, they're almost always set at a level where incumbents have a clear advantage over challengers because there's tons of political science evidence that shows that what challengers spend is much more important than what incumbents spend. Incumbents have free media, free attention, name recognition, and so on in advance. And if you boil it down to this, the argument that we can't allow government to do this is the Federal Election Campaign Act. As I say, we know what government will do if given this power. And how do we know that? Because they did that. As Joel and I suggested, they put a limit of $1,000 on what anybody could spend, not even adjusted for inflation over the years. When the internet first came up in the late 1990s and began to be used as a campaign device, the reform groups argued vociferously, as did certain members of Congress, that we on the FEC, and then I was on the FEC in the early 2000s as they were making this argument, that we had to regulate this internet thing. We couldn't have these people saying whatever and going off all over the place. Remember when Buckley started, you had 3 television networks and a handful of national newspapers and news magazines. They didn't want the broad discussion that could come through the internet or elsewhere. So in other words, if you view the First Amendment as something that says, we don't trust government, if we trusted government, we give them all this power. Maybe it would make it better, but we don't trust it. And if you want the reason why we shouldn't trust it, we can just look at what government has done when, they were given that power before Buckley said, no, you can't do some of these things. So to get on to the question, then how has Buckley shaped things in the future? I mean, it's had a number of jurisprudential issues. And I think one of the key ones goes to something that Gene noted as an argument. I mean, a lot of people do want restrictions as an egalitarian measure. Again, in my mind, what we don't want is this government deciding who's spoken too much, who's spoken too little. We need to hear more from this group or that group. I think that's wrong, but it does strike deeply to Americans in a first impression that we should all sort of be equal. And that argument has been taken off the table by Buckley. So what we've had over many years is an argument where reformers come in, those seeking regulation, and they try to make egalitarian rules and arguments, but they make them in the guise of talking about corruption, so that the entire jurisprudence becomes just a little bit weird. One of the cases that Citizens United overruled was a case called Austin versus Michigan Chamber of Commerce, which was a case that stuck out from Buckley. I think even most people who don't like Buckley admit it, that Austin really didn't follow Buckley, although it claimed it did. Austin claimed it did by saying, well, we're talking about a different type of corruption, the corruption that comes when somebody has more money than someone else and more access, as opposed to what Buckley was talking about, exchanges of legislative favors for campaign contributions and so on. So you have a kind of a strange jurisprudence that evolved that Citizens United actually kind of did away with by reinforcing the idea that Austin was wrong, that by corruption, we mean exchange of votes. And although we understand that a lot of people are interested in the equality effort, that's not what the First Amendment allows. And I think that was a key thing. As a practical matter, the court's support for contribution limits. And by the way, I think Jean's made a really good point. Over the years, she's kind of convinced me that the court got it right there, at least as a jurisprudential matter, if not perhaps a policy matter. But one of the things that you have is with contributions limited, but expenditures not limited, and contribution limits have not kept up with inflation over the years, let alone the fact that political spending has grown faster. What you have is a situation where candidates find it more and more difficult to raise money that they need to campaign. They're unlimited in what they can spend. They're limited in how they can get the money. As one candidate famously said, it's in running for president, it's like trying to fill a swimming pool with a teaspoon. We can only get a small amounts of money from each particular donor. And then that takes up candidate time running for office, and then the reform groups come in and say, "Oh, this is terrible. Candidates shouldn't have spent all their time trying to raise money. Isn't that a terrible thing?" Not really recognizing that that's part of the consequence of the own decision. So, it's had a lot of effects, but basically, at least to Citizens United, from the very straightforward position that, again, if we're going to say that people have a right to spend their money, that really should apply to corporations. Ultimately, it's important for people sometimes to hear from corporations as corporations. They're part of the American political life. They are made up of people, shareholders, employees, officers, and directors. And so ultimately, Citizens United was just a pretty straightforward application of that principle of Buckley. And as Justice Scalia pointed out in his concurring opinion in Citizens United, he says, in Buckley, many of the plaintiffs were in fact corporations. They were incorporated. And over the years, just one final thought on that, which kind of goes away from your question a little bit. But the interesting thing about Citizens United is that we don't have for-profit corporations throwing lots of money into elections. Rather, it's nonprofit groups, so the Sierra Club and so on, that before were limited to in what they could spend direct from their corporate treasury. Even after Buckley, if they spent it specifically to advocate for the election of someone, they could talk relative to a candidate, but if they said vote for or vote against this person, they were limited in doing that. Those have been the big beneficiaries. For-profit corporations still account for a very, very small part of American political spending. In the races since Buckley and the election cycles, it's varied from between about 1.5% to about 6% of total spending that's spent by for-profit corporations. So there's empirical issues that go as well to responding to the kinds of arguments that people make as to why Buckley got it wrong. Again, that concern about corporate dominance or whatever it might be are not always true as an empirical matter.
I'm glad you gave those statistics. It's funny. Put me in the category. I'm probably like a category of very, very few people that, to the extent, as we've talked about, that money facilitates speech. And given that political speech is so vital to the health of our nation, I love seeing enormous spending figures in elections. I think that they're a sign
nobody ever complains about their side spending. People who agree with Elon Musk tend not to be terribly upset by him spending a lot of money, or if they agree with George Soros, they think, yeah, he's definitely got the right to do that. What about Musk, by the way? But it's the guy on the other side that people really think is not good. And that just points out that very oftentimes the people who are spending what we consider to be the big money actually are giving voice to many people who otherwise would not have it, who would not be able to spend a lot of money on their own and reach many people.
That's right. The pooling of resources is so important to getting ideas out. Since we're talking about some aspects of this holding and its legacy, and since you've been bringing up, Brad, this vital question about the thorny nature of government getting involved in the business of deciding who can say what and when and where and how. I'm going to throw this out there. I don't know which one of you wants to take it up, but another critique of Buckley from some is that it upheld the provision on mandatory spending disclosure. Now, it trimmed it back a little bit by making this distinction between express advocacy versus issue advocacy, but one of its legacies is a lot of words, a lot of conversation in the ensuing years over the magic words tests and other things. Who wants to kind of talk about that aspect of the decision?
Well, I think I'll volunteer because I was the guy who argued against the disclosure provisions in the Supreme Court, fresh from my victory on the disclosure provisions against the ACLU in the Circuit Court. And I think the argument was a little bit. I had to walk a fine line because we were not opposed to disclosure, period. We didn't take a sort of pure libertarian view that the government has no business in finding out any of this stuff. What we said was the limits are terrible because they're direct restraints, but disclosure can be a direct restraint too. And so the disclosure laws are too deep and too wide. They down to $101. Nobody takes your phone call for a $101 contribution, even in 1976. And they were so wide that all the minor parties and all of those and independent groups who spent money to advocate, all of them were treated as though they were General Motors, and the price for associational privacy was just too great to bear. So what we said was, we think there is a place for what we now call smart disclosure, namely large contributions to major party candidates. But beyond that, there should be no disclosure or minimal disclosure. You can find out if some company's employees are giving a lot of money to a member of Congress candidate by massaging how many donors from a certain company and how much the average amount is, without saying who the names of those people are. Now, back in the day when we were challenging all this disclosure, I mean, this was lifeblood to controversial cause organizations. I found myself looking back at two NAACP cases in the 50s and early 60s, cases where the southern states, after the Brown decision on school integration, were basically trying to shut down the NAACP and keep it from implementing the Brown case. And so one thing was to say, as they did in Alabama, oh, wait a second, you're a corporation and you're a foreign corporation. You're from New York, for God's sakes. So in order to operate here, you have to give us a list of all your members and contributors and officers. Now, will harm befall them? That's not our business. We're not hurting them. We're just requiring a list of a corporation. And in that case, NAACP v. Alabama, 1957, I think, Justice Harlan, sort of a conservative, although he was a great free speech guy on so many issues, Justice Harlan basically said, the First Amendment not only protects free speech, it protects freedom of association. And in this modern world of 75 years ago, modern world, an individual voice is limited. And the way that people amplify their voices is by joining with like-minded others. And so therefore, freedom of speech includes the right to join with others to amplify your speech. That was so important. And number two, things which will restrict that, now that we've called this freedom of association speech, things that will restrict that, like getting your house attacked and things like that because you gave $50 to the NAACP, have to be limited unless the government has the most compelling reason for do so. So it was a corporate speech case, and it was an associational privacy anti-disclosure case. The other case was Virginia said the NAACP can't have lawyers on their staff because they're not a law firm, and corporations can't practice law. And the Supreme Court said, please, we understand what you're doing here. Corporations, that's fine, that's one thing, but they're using litigation to speak. That is speech. And if you're going to interfere with your use of lawyers on the corporate staff because they're corporation, you too better have an extremely compelling reason. So again, the point of it is that we, in Buckley, we use the NAACP Alabama case as the cutting edge of our argument, that just as you should not have to disclose if there was no purpose in the civil rights movement context, you should not have to disclose if there was no real purpose in the campaign finance context. And on that, we kind of got a split decision. As you point out, others, the court limited that speech by independents, which could be subject to regulation, to express advocacy. It then said you can't ban it, but you can at least disclose it. But that the ACLU said, okay, we're home free. We're not a partisan organization. We don't urge the election defeat. We criticize them to the cows come home, but now we're protected by that. And the other thing the court did was to basically carve out what became called the Socialist Workers' Party exemption. If you were a really small, controversial party, even though you might make a small difference on the election, but you could show harm from people being associated with you, you don't have to disclose. And they said it in Buckley, but there was nobody that fit that bill. But 6 years later, in one of the lawsuits that we spawned out of that, the Socialist Workers' Party was given a constitutional exemption from campaign finance disclosure, both of money coming in and expenditures. So the court really took freedom from disclosure very, very seriously. So again, I call it a win and lose. We lost the heart of it, namely contributions of as little as $101 to candidate, major and minor party candidates. And the court said that was indeed low, $100. That would be at least $800 today. I really think the low level of disclosure thresholds, both at the federal level, they finally raised it to $200. It's still the equivalent of $25 in 1976. And the other thing is, in the 70s, all the government documents were on a yellow paper in manila folders, file cabinets. You know where they are today. And so I tell some of my students, if you want to have fun, dial up the Federal Election Commission, put in employer Brooklyn Law School, and you will see how many of your professors and others affiliated with law school have contributed and how much and to whom if it's more than $200 in a year. And it's kind of interesting to see how that plays out. I think the low level of disclosure at the state, many states, New York, it's $100 and you're disclosed, is a kind of a political voyeurism, that there is no good purpose. You can get how many people from a company contribute different ways without identifying those people. And I just think that's one of the really, if I were king, I would knock that out in a minute. I would have disclosure at the level that will get Senator Schumer to answer my call. Okay, I don't know exactly how much that is, but I know it when I see it, and it's not $100.
Yeah.
Think by the way, with that.
So again, we got half a loaf. We saved the ACLU and all the issue groups by express advocacy. We saved the Socialist Workers' Party and all the controversial parties by the Socialist Workers' Party exemption, but we lost everyday disclosure, and I just think that's really bad.
I just want to emphasize what that means to like actual people. I mean, like if you're a person going in for a job interview, the guy sitting opposite you while you're sitting there talking to him could look up your campaign disclosures real quickly and knock you out. Your neighbors can look it up in this day and age, and we find a lot of political violence and threats, for very low contributors who, as Jill says, are not really influencing. They're not the guys who are making politicians drop all their other business to pick up the phone. Yeah. And I think some people need to realize that's there, and it's there now in today's society.
I'm sorry, go ahead.
Oh, no, go ahead.
I was going to say, I'm reminded, if you go back to Buckley, the vote against limits was 7-1. And if Justice Douglas hadn't been forced off the court at exactly that time, it would have been 8-1 because he was furious about all the limits. Apparently, he wrote drafts of opinions striking everything down. So it would have been 8-1. And the only person who supported limits on contributions and expenditures was Justice White, who had a deep political experience with President Kennedy's campaign and all that, and made some of the very good points that Eugene is making, that you have to limit expenditures, so you limit the money chase of contributions and all that kind of stuff. But he was the only one that did that. Chief Justice Berger was the ACLU card-carrying member on that case. He wrote a dissent which basically agreed with everything we said in the briefs. And what he said about disclosure was, he said, the middle-level business executive who wants to support a Democratic candidate, or the labor union official who wants to support a Republican candidate, they're not going to do it. If they give more than $100, their name is going down on a list, and their adversaries at work and other are going to find that out. And in a society which is too often embraced counterculture, cancel culture. As Brad points out, you're sitting there in an interview, the person is dialing your name and FEC, and now they know what your politics are. I just can't believe we still tolerate that.
Yeah, I mean, that's all I was going to say is that for all I admire the courageous findings in Buckley, I think this is a provision that has aged the most poorly.
Yes.
It did not seem to expect the world that we live in now, where you can have instantaneous disclosure. And as a reporter who has written deeply about the growing intimidation tactics that happen in politics continually, I've come to actually find NAACP versus Alabama one of my favorite cases. And I've actually been thrilled to see that the court, after decades of somewhat ignoring the precedent of that case, has of late been taking disclosure more seriously and the threats of disclosure. I want to just...
I'm sorry, I just want to say one other thing. I agree with everything you just said. And that Americans for Prosperity case is, I think you're referring to that, is such an important case on protecting disclosure. And it troubles Brad, I know for sure, a lot of the groups that are challenging the disclosure and all of those have tried to get the Supreme Court's attention on talking about the issues we're talking about. And I think in one case after another, the last 4 or 5 years, the court has sort of had a blind spot. For whatever reason, they haven't been willing to get into it. And so we have to suffer really a Kafka-esque kind of world on disclosure.
Can I ask a quick question? I'm sorry.
Yeah.
So I totally appreciate these arguments. I think the concern that people will be deterred from donating by fear of social retaliation or economic or even criminal retaliation in some situations is a serious concern. At the same time, it is a pretty common argument of those who want to have pretty broad rights to spend and broad rights to contribute. To say something like this: yes, we appreciate that there's a risk of corruption, but the right way of dealing with the risk of corruption is not suppressing speech. The right way is more speech. The right way is disclosure, right? That instead of just sort of presuming that a large contribution to someone is corrupting, we should allow them, but then have it be publicized so that the voters can decide for themselves. And I take it Joel's response is, well, okay, that's true, but there's got to be really a material risk and not just at the $100 level. I think that's probably right. But also, what would be your threshold? Where would you say that, notwithstanding the First Amendment rights to speak and to associate, and to do so anonymously without required disclosure. Notwithstanding that, it is permissible to require disclosure as to certain kinds of independent expenditures or contributions. Tell me about both, if you could, please. Past this point, it's okay. And by the way, one possible answer, maybe it's different for a presidential campaign than for a campaign for a House district or for a small state legislative district. But where roughly would you draw those lines?
One reason you're one of my heroes, Gene, is that you always beautifully state both sides of the argument. And so
it's my job.
Well, it's my job too, but I'm afraid the advocate in me sometimes overcomes the academic in me. In any event, I guess the answer is what I gave before, to paraphrase Justice Potter Stewart. When you see it, pick a level that will get the attention of a politician, and it's not $100. It's kind of like I was teaching the Rucho gerrymander case, and I think it was Kagan in her dissent said, we may have a hard time figuring out a standard of the kind of gerrymander that would violate the Constitution, but this one clearly is over the line, and it would do it. And I guess I would take that kind of thing. With multi-million-dollar congressional campaigns, I would think at least $10,000, okay, or maybe even $5,000, or maybe even $1,000 if we're negotiating here, but certainly not the equivalent of $50. It punishes people for it's really almost a violation of rational basis review, I think, as well as stronger First Amendment stuff.
So it's an interesting point. You might say, let's look at the amount spent in the race, the typical race, and then perhaps have some percentage threshold.
Exactly. I mean, just
So
like
it
you
may
gave
differ
DeWalt.
for a state legislative
Yes.
race where there could be just 10,000
Right.
voters in a particular district
Right.
than for a California Senate race, which of course, because of the tens of millions of voters, could cost much more.
Right. I think in a way, I just thought you could use the equivalent of a ballot access standard. If you have to have 5% of the signatures in the community to get on the ballot, maybe you have to give 5% of the candidate's annual budget in order to have to disclose that. Would you use that kind of a
Yeah.
numeric?
If I were a candidate, and the question was, at what point do I notice a contribution? It would be well below 5%.
Well, it depends. Depends what
Right,
office
right.
you're
Among
running.
other things,
City
among other
council or
things,
president.
pardon?
Okay. You know
Yeah.
what? You guys are not going to settle this today.
You think?
Although, the wonderful thing is that there's progress being made here. Imagine how much would get done if all of us were in charge, right?
Yes.
Before we actually do run out of time, and before I have Brad kind of have a final question for him, but I want to touch on one more aspect of this case, which you mentioned, Eugene, and I bring it up in part because I think it was actually really important. It got a lot more attention at the time than it gets now when we think about Buckley v. Valeo. I also bring it up because it's kind of back on the news scene in a different way. But you mentioned this provision in it in which the Supreme Court held that Congress could not appoint the members of this new body, this Federal Election Commission. And, it was a very important separation of powers holding. Also kind of one of, in my mind, like a real check on this growing administrative state that we had happening in the 60s and 70s in DC. Of course, this issue about independent agencies and presidential appointment power is coming back up again in front of the court, given some of Donald Trump's firings recently of independent agency peoples. But tell us just a little bit about that aspect of the decision.
So, the federal Constitution provides in the Appointments Clause that the president shall appoint various officers, appoint judicial officers, appoint executive officers. And it actually does allow judges to appoint certain officers too. Judges, I believe they appoint federal public defenders in some places. They may appoint clerks of court and various other things. But it does not provide for appointment by Congress or by either particular members or officers of Congress or by Congress as a body. That's just a power that is not vested in the legislature. Now, of course, that's a general rule. We see some exceptions. There are officers of the Congress who are appointed by Congress or can be at least appointed by Congress. Certainly staffers can be hired by Congress and such. But what the court has, I think, quite reasonably said, well, those are ones that don't exercise executive power or judicial power under the Constitution. If an officer exercises executive power, it has to be appointed by the president. There's a controversy, of course, right now, pending before the court, about removal, whether the president has unlimited authority to remove. But the appointments point is, the text is pretty clear that it's only the president, again, setting aside judges for certain kinds of situations, who can appoint officers. So the court says, look, the Federal Elections Commission was not merely an advisory body. I believe the Civil Rights Commission actually is an example. And please cut this if I'm wrong on this, but I believe the Commission on Civil Rights is an example of something that is seen as a purely advisory body, and therefore there can be appointments by Congress to it. But the Federal Election Commission was an executive body, and appointments have to be or cannot be done by Congress. Interestingly, unlike the Bill of Rights provisions, which basically, with very few exceptions, apply to states. The separation of powers provisions in the federal Constitution do not apply to states, generally speaking, and different states have very different approaches. Obviously, some states elect judges, most states in some measure elect judges. Federal system does not. Many states have a plural executive, my own California, right? We separately elect the governor, separately elect the attorney general and various other people. And There are many states in which members of commissions are appointed in part by the state legislature. I believe my own California again is one of them. But I don't think it's just sort of a weird blue state thing. My sense is that this is not uncommon. So it's not the only way of running a railroad, right? It's various states have very different approaches to many aspects of the separation of powers. But under the federal constitution, it seems pretty clear that indeed Congress can't appoint members of any agency that has real executive authority as opposed to just advisory.
Well, another reason to celebrate Buckley, because as we were discussing earlier, counterfactuals, how terrifying to think of Congress running around naming all the people for all of these agencies. So we can be happy about that.
Right, but not so terrifying that states just all recoil from that, right? They do. States do have state legislatures appointing the agencies, and the skies haven't fallen. I mean, maybe in California they have fallen.
I was going to say, I don't know if I would point to California,
maybe.
But
I just happen to know this, but this is not uncommon throughout the country.
Okay, Brad, kind of finish us out here by talking about the future of campaign finance reform, because, obviously the advocates of more campaign finance limits have not disappeared. We continue to have this discussion. They also recognize that Citizens United, those who truly are in the know, alone is not the boogeyman here, and many of them are still gunning for Buckley if they, ever had that day. Is Buckley on solid ground? What are the odds of the courts changing course here?
Sure. It's a great question. Let me say first, I think the short-term battle that we'll continue to see is this battle over disclosure, actually, because that's the part that Buckley was sort of less definite on. It trimmed the disclosure law way back, but left that, as Joel says, down into very, very small amounts. And the courts have not been very good about, I think, kind of following the kind of leads, the hints, the spirit of Buckley, and the Supreme Court hasn't been aggressive in policing it. When the Supreme Court has stepped in, it's stepped in to protect small donors from disclosure. Americans, the Bonta case that Joel mentioned, Americans for Prosperity, a case from about a quarter century, I guess almost 30 years ago now, McIntyre versus Ohio Elections Commission, where the court said you can't demand disclosure of small donors in ballot initiatives and so on. But that's a big issue. And very frankly, the pro kind of regulatory camp seeks to use disclosure not just to uncover maybe patterns of corruption or let voters know who are the big donors, but I think that they do try to use it in the hopes that it will cut back on the amount of speech completely, either by intimidating people or simply the bureaucracy of it. One of the things I noticed on the FEC is, you can tell a campaign you can't take contributions from a corporation. You can't take contributions over $1,000. Your average treasurer can handle that without much difficulty. You ask him to worry about the disclosure forms and so on, and filling those out for a large campaign with tens of thousands of donors. It is a big mess, and it really burdens small campaigns and local campaigns. It keeps people in very small campaigns. Most states have this kind of law. So you have races for village council and township trustee and county commissioner and so on. And oftentimes candidates in those races are just like, it's too much hassle to take small contributions from people. The candidate, will just pay the $3,000 I'm going to spend running for office. And that cuts people out of politics at the most basic level, where we kind of first start getting along and figuring out how it works and how you compromise and work as a team. And I think it's been very unhealthy. But that's the big showdown area now. And I think in the end, what we'll probably look at is something like a common law approach that Joel kind of hinted at. We'll say, well, that's clearly too low. And then there'll be something we'll say, well, that's clearly okay. And we'll end up with something. And the people who are more take a firm approach, it's none of the government's business, will not win out, but nor will the people who keep pressing first dollar disclosure are not in the long run, I think, going to win either. Now, in terms of Buckley more generally, it's 50 years old now, and that's why this is an important anniversary. Obviously, people continue to go after it. The court obviously can overturn 50-year-old precedents. It recently overturned Roe v. Wade when it was about 50 years old. So there's always that possibility. But I think in the end, we're probably on pretty good grounds, at least against the kind of regulation that would be so over the top, because again, we've seen it, and I keep going back to that approach. We saw what Congress did, and we've seen what states have done in the years since that have been, following Buckley, courts have struck down. They don't put a cap of $1 million, to use Gene's approach. And I always said, if the cap were $1 million, I might not agree that it should be capped, but it probably also would not have become my life's work fighting against this. It'd be a more manageable sort of thing. But we've seen what legislatures will do. And I think more and more we're hitting the point where the court is simply not going to revisit Buckley's core holdings. It may allow more regulation, certain makeups of the court. It may swing back and forth there at the margins, but I'm hopeful, cautiously optimistic that, if we hit a point where Buckley's going to be overruled, our democracy is really going to pot in a whole bunch of ways at that point, because people are going to see it. We just can't say nobody can spend more than $1,000 to communicate their views about politics.
Well, I'm going to take that hopeful view. And you're right, this is a very important anniversary. It's such an important issue. And that is why I want to thank you, Eugene, Brad, and Joel, for all the work you've done on this over the years and your time here today explaining it so well. I want to thank everyone who listened. If you are tuned in, it's because you care about the body politic. And obviously, we want to thank the Institute for Free Speech for putting this on.